Thanks so much, Laura, and welcome everybody this afternoon to this program, which we're very excited to bring you. So the program, of course, is about the DCA regulations that were published in May. And there's 4 of us who are going to be participating today. Let me just do some quick introductions of our 4 participants. And Laura, by the way, I've lost our screen, our PowerPoint screen. In any event, the 4 people presenting are Arnold Calabrese, who is my partner, and he is vice chair of Becker, New Jersey's Community Association Practice Group. He's also a member of the Construction Law and Litigation Practice Group. He has over 34 years of experience in representing community associations and as being an attorney involved in construction litigation matters. So Arnold is joining us. Next, we have Mohammed Saliani. I know many of you people know Mohammed. Mohammed is a principal in Wilkin and Gutton Plan. He is, of course, a CPA, and he had joined the firm in 2001. He specializes in providing audit review and compilation services to not-for-profit organizations, closely held businesses, and real estate entities, such as community associations. He is a co-practice leader of the firm's Community Associations Group. And last but not least, Brett Philo. Brett is a co-founder of Shift Digital, a digital development and marketing practice. He has partnered with Becker to produce both Becker Ballot and the Community Association website management software, mycommunitysite.com. Brett will be talking about electronic balloting today, which I think has become an ever more important topic given what we are about to discuss. So a quick overview. I'm just going to do a kind of an introduction. How did we get to where we are today? And then I am going to turn it to my partner, Arnold, who's going to talk about the changes between the Radburn Law and the Radburn regulations. And then Mohammed is finding that he's getting requested a lot more to do election services through his firm. And he's going to talk about some of the practical issues, particularly given the Zoom meetings we're all having during the pandemic. And then Brett will come back and talk about the election process and the use of electronic balloting. And if time permits, I will finish up with a couple of non-election issues that are in the new DCA regulations. So Laura, if we can go to the next slide. So we all know that this started with the Radburn Election Law. I just want to comment on that for a minute before we go to the regulations. You know, that law came about in 2017. It was a result of Senator Gordon coming to us. When I say us, I mean the CAI Legislative Action Committee, and saying, hey, we need legislation that will guarantee fair elections in community associations. But my goal is not to create burdensome requirements, simply fair and transparent requirements. So I'd like to work with you guys so that we can come up with a bill that works for everybody. And we said, great. I had the privilege of working with Senator Gordon in connection with the drafting of that bill. That bill went through a lot of drafts, both to make sure that his goals were satisfied and that the bill was not overly burdensome. And as I'm sure most of you know, it changed election procedures, and then that it had a required call for nominations. It had candidate qualifications that were limited to being an owner and being in good standing, meaning that all charges had been paid. It required a 14-day annual notice meeting rather than most bylaws having a 10-day required meeting. It required sending proxies or absentee ballots with the notice, and it allowed owners to send proxy or absentee ballots by fax or email. For most associations, this was no big deal. I would say for 90% of our associations, they were doing most of what was required anyway, and they tweaked their process, and they quickly fell into line with the statute. Now, if we can go forward, Laura, to the next slide. So It also authorized, in addition to the things I just mentioned, some of the good things it authorized for us was electronic balloting without any requirement to the bylaws. It permitted negative vote to amend the bylaws, and without going into detail, that simply meant a simplified method of getting the bylaws amended. And it allowed the board to amend the bylaws to conform with law, okay, without a vote of the owners. All good stuff. We thought those were all really positive things for us. And then the next slide. Okay, now we get to the DCA rules. What went wrong? Well, you know, last August, the DCA published, last June, DCA published proposed regulations. They came out, we saw a lot of issues with them, and a group of us on the New Jersey CAI LAC put together a 25-page letter at DCA's invitation, because those rules were subject to comment. We put together a 25-page letter that basically spoke about what the issues were. There were a lot of issues in those rules. We weren't the only ones. Some associations put in comments, other interest groups put in comments, and there it sat because those comments were due by August 14th. On May 18th of this year, DCA issued those regulations. And those regulations added numerous new provisions that were not in the Radburn law. They were, and I say this sorrowfully, poorly drafted and very burdensome. There was inconsistencies between rules and even within particular rules themselves. There was inconsistency with the actual Radburn law. We also objected because DCA proceeded without legislative authority. Now, I'm not going to get into the weeds on this. I'm simply going to tell you that we elect legislators to adopt laws. Legislators can delegate rulemaking authority to administrative agencies. And of course, the Department of Community Affairs is an administrative agency. There was no delegation in the law that adopted the Radburn requirements. Instead, DCA is relying on a 1978 original adoption of the Planned Real Estate Development Full Disclosure Act, which was completely a developer-oriented bill, which did give DCA regulatory authority over that bill to say, well, everything that came after, we also have the right to draft regulations. Suffice to say, we disagree, but DCA went ahead anyway. Even though those rules were issued on May 18th in the middle of a pandemic, there was no phase-in period. There was no ability to say, hey, these are going to become effective as of October 1. Or some later date that would have given an opportunity for everybody to get up to speed on what the rules required, whether we liked them or we didn't. And of course, the pandemic all made this much worse. So that's what we are dealing with today. These rules came out in the middle of some elections and created enormous amounts of confusion when they were published in the middle of an election process. All right, next slide if I can. Thank you, Laura. So after this all occurred and we saw that DCA had made virtually no changes to their rules despite numerous comments by numerous commenters, CAI decided to appeal these rules, and that appeal goes directly to the appellate division. So currently a lawsuit was filed in July concerning this, and DCA is now seeking a dismissal of the suit. Briefs have been filed in front of the appellate division. I'm optimistic that we will be okay following the DCA's motion, meaning that we will win the motion and it will not be dismissed. We did ask DCA to voluntarily stay the regulations while the suit was ongoing so that we could try to work out with DCA some of the rough spots that you're going to hear about today and you're already experiencing. DCA said no. We will go back to the appellate division. assuming the case remains in place, asking it to issue a stay. They're not easy to get in court, but we certainly will try. So CAI's position on the litigation is DCA had no legal authority to draft the rules. Some of the rules are incomprehensible. The confusion is understandable, but not necessary. And I will tell you that if these rules survive, there will be a fair amount of litigation over their meaning, which is going to be expensive to associations, and we do not want that to happen. So with that, I am going to ask Arnold to now pick up and actually get into the details.
Thank you, David. I appreciate that. Hi, everybody. I want to thank you all for attending today. Hope you're all doing well and staying safe. As David mentioned, I'm going to review some of the changes within the DCA regulations affecting board member elections. As you know, and he mentioned, these regulations were issued in the middle of a pandemic without any phase-in period, giving associations no reasonable time for the adoption of policies or procedures to conform to the new regulations. Most associations and managers found themselves in a situation where they needed to revamp their entire election procedure to conform to the newly adopted regulations. This created some chaos and confusion in light of the differences between Radburn law and the new regulations as David outlined. Have my slide up? Okay, great. Some of these changes affect members' ownership rights. For developers, it was common practice for them to be entitled to an automatic seat on the board if they still maintained an unsold unit in a development. This would occur usually after 75% of the units have been sold and the membership takes over control of the board. However, under the new regulations, a developer who retains at least one unit as a rental unit shall not be entitled to an automatic seat on the executive board. This may affect some boards who currently have that situation in place and may need to now fill that seat with a member elected representative. For affordable units, the DCA inserted election requirements as well to provide that associations cannot prohibit, limit, or restrict affordable unit owners from participating in elections, and to confirm that affordable unit owners have the same rights as market unit owners with regard to elections. However, one of the most complicated requirements in the new DCA regulation is a requirement that associations must reserve a seat on the board for affordable units to fill if the affordable units represent a minority of the units in the association. This presents many issues, especially where board composition is already established. You can imagine the problem created when an incumbent board member wishes to run, but their seat is only one available for the affordable units to choose. However, the regulations as written allow for that seat to be filled by anyone, as long as they are qualified and elected by only the affordable unit owners. Therefore, in my scenario that I mentioned, the incumbent board member could obtain a nomination from an affordable unit owner or run to fill the seat elected by only the affordable unit owners. Additionally, candidates must now declare what seat they are running for if there are different seats up for election. So in a mixed market affordable community, a candidate will have to be nominated or declare that they are seeking election to fill the affordable unit seat. But what if nobody runs for that seat or isn't nominated for that seat? These are problems presented without answer in the DCA regulations. Likely the best approach would be to fill the seat by appointment until the next annual meeting, when the unexpired term would be up for election by the affordable unit owners, assuming they put somebody forward for election. Clearly, navigating the affordable unit requirements could present traps for associations and should carefully be analyzed with association counsel to ensure the fairest possible procedure in light of these regulations. In mixed commercial and residential unit communities, the new regulations prohibit commercial units from controlling the board. The DCA regulations state that regardless of the number or value, owners of commercial units in a development shall not constitute a majority of the executive board. we can certainly imagine the complaints that will arise where commercial units represent a majority of the units in a development. But again, the DCA provides no answers to resolve those types of disputes. Lastly, the DCA regulations prohibit any person or entity from holding more than one seat on the Board of Trustees. This expands upon the Radburn Law's previous provision that everyone understood that clearly prohibited any unit owner from holding more than one seat on the board. This now expands it to include any unit owner or entity that owns more than one unit. They also can't hold more than one seat on the board. Laura, can you move to slide 10, please? To the next slide. I'm sorry. If you can go back, apologize. There you go. In order to conduct elections without dispute or subject to criticism, boards and managers need to carefully review the Radburn Law and the regulations, make sure that they stay within the timelines permitted for the election process. Associations must send out both a call for nominations and an election notice, but at different times. The call for nomination must be sent at least 30 days, but no more than 60 days before the notice of an election or annual meeting notice. Persons who failed or submit their name for nomination as a candidate in order to be included on a ballot that's being sent out to the membership and used for the meeting, they can now solicit votes and be included as a write-in candidate so that they are not prohibited from running from the board. Previously, there was some question about whether or not write-in candidates were required, and these regulations now make it clear that write-in candidates need to be permitted. An additional step is imposed upon associations in the election process is that anyone who is delinquent and not in good standing must now be given at least 30 days notice before the election, informing them that they have the right to alternative dispute resolution and the right to become qualified to vote within 5 days prior to the election. This step was not originally contemplated by the Radburn Law, and adds a additional time frame that needs to be considered when the managers and associations are putting together their election procedures. The notice has to state why the resident is not in good standing so that they can identify what the problem is and try to resolve it, and also submit a request for ADR to discuss that particular complaint. Unfortunately, the DCA regulations did not provide a deadline for delinquent owners to request ADR. Clearly, to be effective and without delay of the election results, an ADR would need to be conducted sometime prior to the election meeting. And therefore, associations will need to have in place an ADR policy that can be implemented in a quick and timely manner to conduct the ADR before the election. Being prepared and being ready will save associations from the headaches that will obviously result if an ADR cannot be completed prior to an election. But in those cases where it can't be completed for whatever reason, a provisional ballot should be used pending the outcome of the ADR, so not to delay the election meeting that was previously noticed. To complicate matters even more, the DCA requires that ballots must be tallied in public or publicly. Therefore, associations will have to have a procedure in place that allows the membership to observe the election judges counting ballots. This doesn't mean that they need to actually see the ballots or see who is voting, but just that they can observe what the election judges are doing. This could be tricky in this current environment, especially because of a lot of meetings being conducted virtually. But whether it's in person or virtually, there's going to have to be time set aside in a meeting to allow the membership to observe the counting of the ballots. For larger communities, the counting may have to occur maybe at a later date to prevent unreasonably long meetings from happening. We all know how long ballot counts can be, especially in larger communities. And this could certainly add a lot of time and cost to the process. In consideration of privacy concerns, again, whether in person or virtually, the determination by the election judges of the qualification of candidates should be performed without identifying the units in arrears. The election judges should be able to take the information and review the arrears list without notifying the membership. At some later date, if the membership wants to observe the records of the association, they'd be entitled to do that, but I don't believe it would be proper to do at the meeting or in the virtual meeting. Once ballots are tallied and the election results are announced, the ballots must remain available for inspection by any member of the association for a period of at least 90 days after the election. If an association is considering using electronic balloting to streamline the process and make it easier for members to vote, as Brett, one of our panelists, will discuss later, the DCA regulations now require that it be authorized by the association's bylaws, as David previously mentioned. To take advantage of that and using electronic balloting, it's recommended that a bylaw amendment be considered, which no doubt will save time and money for the association and streamline the process. Associations should consult with their legal counsel to determine the best approach for amending their bylaws. As Dave mentioned, it could be typically, what we're commonly used to, an affirmative vote of the membership by some percentage interest or percentage of the membership, or it could be approved by the board and then sent out to the membership with a rejection ballot. And as long as 10% or more do not send back the rejection ballot, the amendment would pass. I think that was a question that was raised in the question and answer forum, and that I think is the answer to your question, so that a rejection ballot can be used. To help you visualize the notice requirements, this next slide represents a one-page summary of the timeline for proper notice to conduct a board election. As you can see, it tries to lay out in order what the notices are required by the new regulations and by Radburn. Some of these you may be already familiar with, but now that we've added in the notice to the membership in good standing, you can see how the timeline needs to be adjusted. But putting something like this chart together, it will assist associations and make sure that they meet the required timeframes for the notices. You can see that you can work backwards from the annual meeting date to fill in the dates that are required. It's an easy method. I'm sure there's others out there that you may find as simple and easy to use, but I found this to be very helpful.
Arnold, just one thing I would point out on when the absentee ballots and proxies are due, the regulations do say they can't be due more than 1 day before the meeting.
Thank you, David, for pointing that out. We can adjust that timeline to add that in parentheses underneath that bullet point, and I guess we can make that available to anybody that's on the webinar right now. We can move on to the next slide. Thank you. Now we can discuss some of the more specific notice requirements. The election notice sent to the membership must contain a copy of the ballot used for the election. Now, this could be a copy of the absentee ballot or the in-person ballot that will be used. However, if it's a sample of the in-person ballot, it should be watermarked or in some way marked as sample ballot. That will prevent its production and use by members who obviously don't wish to abide by the rules of the election and possibly may try to submit multiple ballots, taking advantage of the anonymity requirements. It's important to have in place safeguards to prevent multiple ballots from being accepted. This can be done through various means, but clearly having a policy in place is going to help the association and management administer the election. On the ballot, it cannot list the candidate if they are an incumbent. So if there are incumbents running for the board, their name can only be listed. It can't say incumbent, which were commonly used in prior practice. They can't distinguish in any way their name from the other candidates on the ballot. Clearly in our political environment today, it will depend upon your view as to whether or not it is or isn't an advantage to have incumbent next to your name when you're running for the board. But in any event, it's prohibited by these regulations. Additionally, on the ballot, every candidate's name has to be listed in the same font, size, and color. Again, not to distinguish any one candidate from another. There also needs to be space for members to use to write in a candidate. The number of lines available on a ballot to write in a candidate must equal the same number of positions that are up for election. So, for example, if there are 3 positions up for election, there needs to be 3 write-in lines on the ballot. And because all ballots must be cast anonymously, most associations are likely to implement a double envelope system or engage a third-party election service to conduct the election. If using a double envelope system, the election package needs to include a return envelope that requires the voting member to print identifying information, usually in the return address location on the envelope. This will be used by the election judges to qualify that member for voting. The interior ballot envelope, an interior envelope to enclose the ballot will also have to be included in the election package, but this envelope will have no identifying information on it. It will be used simply to seal the anonymous ballot for eventual counting by the election judges. Once the return envelope is qualified, it will then be opened by the election judges, and the ballot envelope will be placed in a pile for them to open while being observed by the membership. If the order in some way can be determined of the qualifying units based upon the return envelopes, the ballot envelope should be shuffled in some way so that no one can keep track of who voted at what point in the order. This is again to protect the anonymity of the members voting. If you're using a third-party election provider, they also will have to put in place similar protections and to protect the anonymity of the ballot, which should be confirmed by the association with that provider. If using electronic balloting, Brett will discuss how that will meet the anonymity requirements during his presentation. Election rules may not prevent a holder of a proxy or a power of attorney from voting on behalf of a member in good standing. Procedures will need to be put in place to permit proxy holders or powers of attorneys to obtain a ballot if appointed either in advance of a meeting or during the meeting. Radburn and the regulations require that email and/or fax ballots be permitted. This could be the method used if the proxy or power of attorney attends a virtual meeting and requests a ballot. If this is the case, the recipient of the email and/or the ballot will need to ensure that the ballot remains anonymous without any identifying information. Instructions should be given to send the ballot if it's by fax with some identifying cover sheet, and if by email, the ballot should be attached to the email, and the body of the email should identify the person and address for which they're voting for. To maintain the integrity of the election and keep ballots anonymous, the DCA regulations require that any ballot depository where they're kept must be secured. Well, what does that mean, secured? Well, associations may have to use a locked box, securing it in a location in a room that's locked and secured, or if they're using a third party, that the third party will maintain the integrity and security of the ballots. They can't be accessible to the membership or to any interested parties. And in practice, this will likely be the association's managing agent or the association's attorney. And if you're using a third-party election provider, it would likely be the third-party provider as well. That was an overall view of what the different requirements are from the regulations to the Radburn Law. And I hope it provided you with as much information as necessary to make your elections in compliance. And that concludes my portion of the webinar, and I'll pass this on to Mohammed. Thank you.
Just before we turn it over to Mohammed, Arnold, there's one good question that directly relates to your portion of the program.
Sure.
And that's asked by Joanne, who says, do the affordable unit owners get to vote twice, once for the regular seat and once for the affordable unit seat?
I think that the regulations would allow them to vote in the overall election for the general seats, but only with regard to the one seat that's up for election by just the affordable unit. So it's not voting twice, they're different seats. So one's a general at-large seat and one is an affordable unit seat. So, if there was only an affordable unit seat available, they would just be allowed to vote once.
But I think the point, which is well taken, is the affordable owners get to vote for all board members. The market rate unit owners only get to vote for market rate board members.
Well, therein lies the problem and the confusion that these regulations have presented to us. But it's a great, listen, that's a great question. And again, hopefully there'll be some interpretation coming down the line that will clear this all up. But I think based upon what we've, looked at and read, we would take the position that they're entitled to vote for the at-large, seats as well as their individual affordable unit seat.
Well, hopefully it won't be an interpretation. There'll be a decision by the appellate division that will say these do not stand. We've gotten quite a few people who have said, will these slides be available? Let me just, so that if anybody else has that question, yes, the slides will be available, but so will everybody who participated will get a link to this webinar. So if you want to go back through it in the future, it'll probably be a couple days after the webinar ends. You'll be able to go back through it. You'll be able to hear the details. You can get a copy of the slides, and you'll see our email addresses at the end. So if you have specific questions, you'll have that opportunity. Sorry,
David, I see there was another question that came in about using email or fax, but what about also using the United States Postal Service mail and to prevent double voting? Well, what would happen is when you're qualifying the votes, after the vote is closed, the balloting is closed, the election judges will qualify the votes, and if any vote came in and qualified, it's going to be marked on the list that particular unit submitted a mail-in ballot, let's say by U.S. mail. And then if they tried to submit it by email or fax, it would show up as being a double vote. And before they were opened and counted, there would be a decision as to which came in first and which one would have to be rejected. So there would never be a situation where you count both ballots.
And of course, the only way that works is that when you email or fax a ballot, you cannot be anonymous. The DCA didn't think through that issue, but you can't be, because you have to have a way to verify that the person who is submitting it is in fact an owner, and you have to be able to verify they didn't already vote.
Right, and that's why during my presentation I mentioned that if it's by fax, it needs to have a cover sheet that identifies who it is, because there can't be any identifying information on the ballot itself. And if it's an email, the body of the email has to identify who's submitting that vote, and the ballot needs to be attached as a PDF attachment, again, without any identifying information. And that way, if there is a double vote by a particular unit or member, that could be put aside and a determination can be made as to which vote is counted.
Sorry, Mohammed, please.
That's okay.
Go ahead.
Yeah, no problem. All right, hello everyone. Thanks for joining us on this webinar. And first of all, I want to say thank you to David and Arnold for inviting me to be part of this webinar. I really appreciate that. Laura, if we can move to the next slide, please. All right, so being a person who's actually done a few of these elections, by the way, I will tell you that requests for performing these elections on my part have gone up probably about 200 to 300%. So suddenly I'm getting a lot more requests to do these elections, because as you know, you need to have an outside person to do it, and management and the board, of course, do not want to be part of that and be involved in actually doing the election itself. And the board, of course, cannot. So I will talk about a few of these practical considerations that we have encountered. One is delinquency listing. So as Arnold told you, anybody who's not in good standing has to be told at least 30 days in advance that they're not in good standing, and they are then allowed to have ADR, and you have that short period of time in which they can request the ADR, and you're supposed to have that system in place so that you can have the ADR. And until 5 days before the you have to be able to have a list that's revised if somebody has clarified their position and they are now considered in good standing. But I think a question did come up here, is that if somebody has requested ADR and it's not happened before that, then technically speaking, I think that person is allowed to then vote, or they have a ballot for them that they can vote, because now they've requested it, so they are no longer not considered not in good standing, if you know what I mean.
Mohammed, if I could just add, jump in there for a minute, not to interrupt, but that's where a provisional ballot would be used.
Right. And so a few other things about delinquency lists, though. So you have to make sure that you have them updated so that when you're actually doing the ballots and when you're checking the envelopes that came in, it's the most updated list that you have. Secondly, do you have a minimum amount that you're saying below which a member is still deemed to be in good standing? I have a few associations where I did the ballots and they said anything below $25, but you have to have that in place beforehand. It has to be in your rules that you're allowed, you're okay with that. And I believe, David, you want to say something about that?
I do, Mohammed, because I slightly disagree with you on that to this extent. The regulations and most documents say that if you owe a penny, you're not in good standing. If you owe anything. Now, to some people that seems ridiculous. They may have a $10 charge outstanding, a $25 parking fee, whatever. But the board can't arbitrarily pick a number. What the board can do, they can waive those minimal charges. So the board can say, we're considering anybody who owes $50 or less forgiven, they're now in good standing. They don't do that, they're not in good standing. And if you try to create a rule that allows people with an outstanding balance and it's a close election, the person who loses that election is going to have, I think, a good challenge.
Right. No, you're absolutely right there. There's no doubt about that. But that's what I meant, is that in the sense that if the board has decided that anybody below that amount they're going to waive that amount, and it's going to be the person's considered in good standing. The other thing is that it depends on when your election date is. If you are within the first few days of the month, and it's within the grace period of when people are allowed to pay their maintenance fees, then you're going to have a certain number of people who have not paid their maintenance fees because technically it's not yet due. But on the other hand, they are above the zero amount, or if there is a predetermined amount, if there is one, then they have a balance there and they are not considered to be in good standing. So do you then consider anything that's between 0 and 30 days not to be included in the receivable listing so that those people can still vote? So that's something that you have to definitely consider when you're setting the date itself for the election. So that's about delinquencies. Then so far we've talked about having the 2 envelope system, having the outside envelope where you validate the person's unit, and then you have that envelope open, and the inside envelope does not have any identification marks on it to show who it is that has voted. And then that envelope is opened in front of the public, and you can then count that ballot. But how do you do that if it is a percentage interest unit? And what happens because now you can't just allocate, it's not one vote per envelope. So you have to have a system in place where even though you're validating it, you can still use that for counting the ballots later on when you're counting it in front of everybody, and not have the people know who it is that's counting. So one way that we have done it, or we in one instance, is that we provided them with random numbers. And so there were random numbers that were put onto the outside envelope and the inside envelope. And those random numbers were then allocated to the listing that we had. And then the ballots were counted that way. And so again, it was shifted, it was shuffled, and the random numbers were then not, of course, in order. So you would not know while you are counting who it is that's actually casting that ballot or that vote. But then, of course, that impacts the time that you're going to take to be able to count these ballots, because you're doing a two-step process here. You're validating it, applying the random numbers, putting it on the other one, shuffling it all, and then opening the other envelope and making sure that you're using the right random number to be able to count that ballot itself. So, and it causes a number of issues for doing the open counting itself. As you know, currently we are in a situation where we really cannot get together. And up till now, the ballots that I have done, we have done them in such a way that we actually did sit in the clubhouse and we were away from the other people. So people could come in and sit 6 feet apart and look at us counting the ballots. However, we have been requested to do one by Zoom. So we're going to be doing one via Zoom where people can come in and watch us count the ballots as well. So it does, put us in a situation where counting them is going to take a lot longer than what it was previously. The last point that I have here, of course, is the owner list. So if you have an owner list that you have out for counting the ballots with all the ballots that went out, and a unit was sold after that, so now you're going to have a new unit owner who, of course, under the Nonprofit Corporation Act is allowed to vote. However, currently your list does not have that unit owner's name. So how do you deal with that situation? And I think maybe Arnold and David, you might be able to chime in here and say, but how to deal with that. But I've not encountered that situation up till now, but it is definitely an issue that might definitely come up in the future. Lastly, before I move on, the cost for all this. As you know, I'm a numbers guy, and we look at this closely. So the associations that have budgeted for elections, currently the cost of their elections are double or triple fold compared to what they were expecting them to be. So there is definitely a cost factor that these new Radburn regulations have brought in that were not considered before. And I'm sure DCA did not think about that or does not consider that a valid issue anyway, right?
You know, on the issue of the owner list, we've been through several of these, and although we do not serve as the inspectors of the election, as the attorneys for the association, we're either in a Zoom meeting where, as you've described, Mohammed, the people who are doing the counting can be observed. And by the way, just a couple of tips on that. We do not recommend, even though the regulations don't speak to it, if you've got a double envelope system, we do not recommend the outside envelope be opened before the counting begins. People should be able to see that the election inspectors are opening those outside ballots. Why? Because once the outside ballots are open, the only thing that's inside is a blank envelope with a blank ballot in it. If they're opened beforehand, there is going to be suspicion that somebody took the blank ballot out, put another envelope with a unsigned ballot in, and then there's no way to verify that the election was valid. So particularly in contested elections, I mean, this all goes by the boards if you have an uncontested election, obviously. But in a contested election where suspicions run rampant, it is not a good idea to, even though it would make it easier, and even though this is more time consuming, we would recommend you not open those outside ballots beforehand.
David, if I could just add, I think that, to be economical with time, you could though qualify those units that are submitting the ballots ahead of time, as long as you don't open the envelope, and you could put them maybe in some order that would assist the election judges in putting, going through the qualifications during the meeting, so that it saves a little bit of time. But yes,
and I think our practice group also takes the position that if you're going through qualifications, and one of the main qualifications being that you're in good standing, you can't talk about people's names who are not in good standing on a Zoom call. That would probably violate the Fair Debt Collection Practices Act. Because of that, either you have to mute the audio during that time, or even better yet, before the counting begins, have already gone through, as Arnold, you suggested would be possible, to qualify the ballots and to set aside, not dispose of, simply set aside the disqualified voters, but keep those. Because if they have to be reviewed later, you want to make sure you have that. And if you disqualify a ballot for any other reason, don't open the outside envelope, keep it intact, and put a note, whether a sticky note or handwritten, on why that person wasn't allowed. I was in a meeting last night with a hotly contested election, and when we compared the names on the outside of the ballots, they didn't 100% of the time match the names on the owner list. We could not get confirmation at the time of the meeting as to whether the ownership had changed or whether there was something we weren't aware of. We set those aside, marked those provisional, and as it turned out, the election did not depend, it would not have made any difference. Those votes could not have changed the outcome of the election, so there was no need to go further on that. But if there were, we could afterwards.
Yeah, just to add in, David, you're right. What we did is we actually did the validation before going in and doing the open counting itself. So this way, and we did set them aside, we had them and we kept them aside, but we did not, of course, in front of everybody, take any names or anything like that.
By the way, somebody asked a great question. Trish asked, how can you say there's an uncontested election now when write-ins are permitted? And that's a good question. And you can only say it's uncontested after an opportunity for people to say, yes, I want to run and I would like my name written in on any ballots that can be written in on. Then it was not uncontested, then you have to go through the ballots. But if that were not the case, you can say it's an uncontested election and you can do the typical asking for affirmation by everybody at the meeting that the people who are running, 2 people for 2 spots, are in fact elected. Mohammed, if you are done, we will turn to Brett on electronic balloting.
Yes, yes. Brett, take it away, of course.
Thank you, Mohammed, and Arnold and David. Thank you so much for including me. I appreciate being here and having the opportunity to chat a little bit about electronic voting. I'll talk generally about electronic voting first. I know that there are some broader questions around electronic voting, and then a few items that were mentioned earlier I can address specifically. I will speak to our approach to electronic voting, the software that we've developed, but you know, I'd appreciate it if everybody just kept in mind that there are a lot of packages out there, and you should be evaluating, if you're interested in electronic voting, you should be evaluating software to determine whether it meets your specific association's requirements, have a demo of the software, watch a webinar, whatever you can to make sure that you are fully acclimated with the tools and with the features that those particular software packages offer. Generally speaking, the goal of electronic voting, particularly in light of the changing regulations here in New Jersey, are to make the process more convenient. You know, voters are located all over the state, all over the country. They may not be in their residence during a vote or during an election. So the goal will be, the goal of the software is to make the process convenient and easy for your voters to participate. We do appreciate the ability, whenever possible, to reduce paperwork. There's certainly a time savings and a cost savings associated with that. I think voters appreciated it, and as association management, if you can save some money in the production of paper and postage, I think that's a huge win. Balloting systems, ours included, should allow you to include any supporting materials. So it's not just the ballot that can be delivered to your voters electronically, but they should be able to see candidate information sheets or any other supporting materials that are necessary for a voter to make an informed decision. And all of those Additional ancillary supporting pieces of material can be uploaded into the system and viewed directly online, so your voters have the ability to review those materials. As a second matter, the software itself should be easy to use, which is certainly why I suggest you take a look at the software as you are evaluating packages, so you can make a decision as to what will be appropriate for your specific membership. Most voting software, ours included again, is based on a very familiar interface constraints. So if you're used to ordering something online using a form-based interface, online voting should really be no different. I think you'll also want to make sure that whatever package you look at works on mobile. Again, not every voter will be in front of their computer, despite the fact that I spend 8 to 10 hours sitting in front of mine every day. They will be away from their homes, they may be traveling, and you do want to make it easy for your voters to vote from wherever they may be located. So mobile is important. Many folks use that now as their primary method of accessing content on the web. Electronic voting really should be no different. And to that end, and if we'll go to the next slide, the goal there is to increase member participation. You want your membership to actively participate in association business. You want them to be able to review the materials and make informed decisions. So by making it easy, by making it accessible wherever they may be located, you will naturally increase their increase member participation. And quite honestly, it's often easier to engage somebody in their email and get them to jump online and vote quickly than go through the more traditional paper balloting system, particularly if it's an election and there are multiple envelopes. And I'll speak to that in a minute because I know there's always a concern around anonymity with regard to elections and specifically electronic elections. All electronic voting packages should be secure. That's the other question that I often receive. How do I know that my password is protected? How do I know that nobody can get my credentials and vote on my behalf or hack the vote? So you'll obviously want to ask those questions. You want to make sure that your voting package uses standard encryption. It's very easy to tell. And again, if you're shopping online, as many of us are these days, certainly in earnest, if you look up in your browser, in that address bar, there should be a lock next to the name of that software that indicates that that communication between your browser and the server that's receiving the information is encrypted. It's secured using technology called SSL. We use standard security encryption, very similar to what you'll see on Amazon or other shopping sites. So that means the minute somebody presses submit in their browser, whether it's to log in or to cast a vote, that data is transmitted encrypted, so that even if somebody was attempting to listen to those packets leaving your computer and going to the server, that what they would see would be nothing that they can use. And then it's decrypted at the recipient's end, at the server. We also take measures to separate association data. So every association that uses our voting package, and again, this is always a good question to ask, that data is separated from any other association that's using the system. Every association has their own unique database where only their data is stored. And in fact, we take an additional measure to separate voter data within that database. So even if somebody was to steal that database, they would not be able to match up a voter with their unique vote without understanding how the software worked. So we try to keep that as with layers of security, and that's something that I think your voters are going to want to hear. They're going to want to understand that their information is kept secure and secret, that the vote information is kept secure and secret, and that you're taking active steps to ensure that there's no real way for that data to be hacked or stolen. And then lastly, we've talked a lot about this, you know, the goal is hopefully to not be counting ballots until 1, 2 o'clock in the morning. And if we go over to the next slide, you know, from the moment you set up your ballot to when you sit down to count those ballots, you want to reduce that manual labor as best you can. So all these systems should provide an electronic reporting tool. Our system calculates the results in real time at the conclusion of the vote. So 1 minute after a vote is concluded, the full results are available within the portal. They can be viewed online. So again, if they need to be shared publicly, or if you're doing it via a Zoom, that screen can be presented and you can see the vote tallies or the results of any specific type of question. And then those results can be downloaded. We provide a downloadable report because we know that despite our best efforts, particularly as electronic voting becomes more popular, there will still be a percentage of people who will vote on paper, and you'll be doing at least a small number of paper counts. So we provide you with a mechanism so that you can download the results and then add your paper count to that report, or vice versa. Again, those reports can always be validated on screen. That data can never be changed, and the vote is locked as soon as the vote has been closed, and that's typically set when you launch your ballot. So we try to make that process very easy, and it should be easy from a vote administrative standpoint, because you're doing the lion's share of the work, from creation of the ballot to managing the voter roster. So the process should be fairly seamless and easy, and reduce the amount of labor at the conclusion of the vote. Lastly, as Mohammed mentioned, cost is a factor. You do want to consider all of the additional costs associated with any upcoming votes, particularly as you get into compliance with some of the changing requirements. So look at how plans are priced. Some voting packages priced per voter or per block of voters, or eligible voters. Others, as we do, are priced based on the vote. So it's a flat fee. You also want to make sure there aren't any hidden charges. For example, a ballot setup fee or a roster setup fee. We don't charge for those things. You should ask those questions as you evaluate packages to ensure that you fully understand what the cost will be to your association. And of course, obviously there shouldn't be a cost to your voter. This is an association piece of business, so that should factor into whatever the overarching costs are for any vote that you need to conduct. With specificity, I know the one question that did come up and has come up a couple of times is election anonymity, and we've talked a lot about the double envelope system and ensuring that there's no identifying information on that internal envelope. You use that external envelope to match it to the voter roster, so you can identify that that person's actually cast their vote, but past that, the count of the vote itself is separate from that internal envelope. The electronic version is essentially similar. When we receive a vote in an election, we separate the vote data from the voter. We record the vote as a tally, and we mark the voter as having voted with a time and date stamp. But that data is not matched, and the vote administrator or whomever has access to the voting portal from an administrative standpoint can't match that information together. They can't see that Brett voted for Mary Smith. There's no way to identify that through the portal. That data is separated out. We do produce a vote receipt report. Every voter receives a receipt of their vote, and it reminds them of who or what they voted for, so they have a record of that. We produce a report that anonymizes those receipts, so it acts as if we have a paper ballot, but it's anonymous. So it's as if we received the ballot that was in the internal envelope. We just create a PDF version of every receipt that's been sent out. We just strip out the identifiable voter information in that regard. That way, if the vote is ever questioned, if there's a challenge, if you need supporting information in the form of an audit, we have a paper trail of, if there were 100 votes, there will be 100 receipts. And if you were to manually count those receipts, it would equal the report that shows you the consolidated vote tally. So, and every system that you look at should have something similar, so you have the confidence that you have the data that you need post-vote in the event there's ever a question that comes up. So I think that concludes my part of this. Happy to answer questions if any come up.
So Brett, I have two quick questions for you.
Sure.
First, how do the inspectors of the election get the results of those votes cast electronically?
That's a great question. So in our system, that report is available through the portal. So the election inspector, through their association contact or through our organization here, would have access to the portal. They would be able to log in, and 1 minute after the vote closes, the final vote tally is available. We do produce in real time a voter status report, so that as voters cast their ballot, if you had a 2-week voting window, on day 2, you could log in and see who voted and when. You couldn't see what they voted, who they voted for, but at least you could keep track of the voting activity. We also provide a similar report at the conclusion of the vote by unit number. So if you wanted to open that report up in Excel or print it out, and you were opening up the external envelope, you could match the unit number or address on the external envelope with that report, just to make sure, oh, I either have a paper vote or I see that they voted electronically. This way you can avoid inadvertently getting duplicate votes. But all that data is available immediately within the portal and is accessible to whomever has been designated as a vote administrator in the balloting process.
And Brett, as you heard, there is this whole issue we've got to go through with the 30-day letter. So the association would typically have given you all the data on the unit owners who had consented to vote electronically. And by the way, that was one question that came up. Well, we have people who don't have computers, or we have people who want to vote by paper. Under the law, people have to sign a consent. It is a consent form that can be good from that point forward. You don't have to go through it each year, but they've now signed a consent. At the time that we're asked to upload the information to you, they're not in good standing, but they could become in good standing up to 5 days before the election. So if they voted electronically, do you have a way of pulling them back out of, or separating them from that total so that their vote is not counted?
Yeah, so if we know that they haven't voted already and the voting period is still open, the vote administrator or we here can deactivate their account, which would effectively prevent them from being able to log in and cast the ballot. Conversely, if they do come into good standing and they are eligible to vote, and they are either not marked as such, their account is turned off, or hadn't been entered in the first place because they weren't in the original data upload, they can be manually added. It takes 2-3 minutes and activated, which will send out an email to that voter so that they can activate their account. And if the ballot is live, they'll see it there in their portal waiting for them to vote. So that process is pretty easy. Every once in a while, you might, the vote administrator might lean on us to do that for them. We'll just ask to ensure that they send us an email with all of the relevant data, including, if they have a signed consent form. We just usually want to see it just to make sure that when we enter that data on their behalf, we feel confident that all the requirements have been met.
So last question for you. Some of the participants today might be involved with cooperatives, and some may be in condominiums that have proportional voting. As you know, cooperatives typically vote by the number of shares they hold, and there are some associations that are condominiums that they vote by their percentage interest, which differs by unit. Can you accommodate votes that are done that way?
We can. We have something in our system called vote weight, and it's a great question to ask. As you look at other systems, we've tried to take a relatively simple approach to it, in that every voter, when they're entered into the roster, is presumed to have a single vote, but we enter that as 100%. So what we enter into the database is 100. This way, if you are in a situation where you use fractional voting, so less than a full percent, or less than a full vote, or vote points, which could be more than a full vote, that 100% accommodates either scenario. So if I own 50% of a unit, my number would be 50. That can be adjusted either in the data spreadsheet before it's uploaded or in the portal itself. And if they have vote points, let's say they have 15 vote points, that 100 would be 1,500, and the system converts it to 15 vote points. So we try to make that process easy. And again, in those scenarios, it's often helpful to just jump on a call with somebody here just so that we can help them either work the voter roster to accommodate that specific set of requirements, or we'll just give them specific instructions and they can run with it.
And I just want to say for the audience, this is not a sales talk for Becker Ballot, but I do want to say there are many good. I don't know about many. There are several good e-balloting services out there. Shifts Becker Ballots is one of them, and as Brett said, you should do your research on it. But I will say one thing, and Brett has been somewhat modest on it. Because they're not a huge company, they're very sophisticated, they do very well. You can get on the phone with somebody like Brett or somebody at his level who can walk you through it, and they will help you get through any questions you might have. That said, we are over an hour, but I do, instead of me going to the couple of other slides that dealt with non-election issues, I do want to give an opportunity to answer a couple of the questions that came up. So the first one is, when can we expect to have all these concerns addressed by the DCA or the courts? The answer is unknown, but it could be up to a year or more before we will get a final decision. Now, if the courts stay the rules while this case is pending, and there's at least a chance of that, at least we won't be burdened with some of these very difficult issues. Okay. Terry Vigiano said, it took us 1.5 hours for 2 people to open and count ballots for a 375 home community, even after organizing and verifying. Yes, that is one of the problems with this system. Terry, it's a good comment. You know, that's why maybe if you have 375 units and you get a lot of votes, have more than 2 inspectors. Even if your bylaws call for 2, no, but nothing says you can't have 4. So, you know, you might want to do that. Chuck Graziano said, if an outside envelope contains both proxy and ballot envelopes, how can we give the designated proxy time to vote that proxy? We're not opening the outside envelope, so we don't know what's inside. Arnold, you want to take that one?
Well, you know, prior practice used to include the proxy and the absentee ballot or mail-in ballot together. That's not advisable any longer because of these regulations. So the best practice would be that in the notice, it advises the membership that if they're going to assign a proxy or they want a proxy, they should request one. It should be a separate form that's given to them. And filled out. If it's part of the election packet that you want to include one, it should again be a separate form, and it should be sent in separately, not included in the instructions should clearly tell them not to put it in the ballot envelope. The only thing that should be in the ballot envelope should be the ballot. Then once they you know, under the rules, as I mentioned, you can't prevent somebody who has a proxy or a power of attorney from voting at the time of the meeting. So, you know, you have to be prepared to have some procedure in place to deal with that. So while the meeting may be going on, you may leave open a period of time for those people to be conveyed by either fax or email a copy of the ballot so that they can then return it again within a limited period of time for the ballot for the ballots to close and the vote to close.
And I think, though, I think what Chuck might be referring to, and although we generally do not use these kind of proxies, is a general proxy, not one that is a proxy ballot. So he's asking, well, if you took a proxy and it's a general proxy and that proxy holder now has to vote the vote, but you don't know until you open the outside envelope, how are you going to do that? My suggestion would be you not use a general proxy. You only use a proxy ballot that includes the ballot. And frankly, since the Radburn law says this can be done by absentee ballot, you know, our preference is to only do absentee ballots, not do proxies. There are times when proxies are necessary, but that gets too far into the weeds in this program. Barbara Jaquette asks, what prevents a homeowner from declaring that they are running for general election seat and also run for the affordable housing seat? does the Radburn Amendment specifically prohibit an owner from running for each type of seat? Arnold?
Yeah, again, the regulations say that if there are different seats, the candidate has to declare which of those seats they're running for. So they couldn't run for both seats. They'd have to declare which one they were running for. You're muted, Dave. Dave, you're muted.
Thank you for reminding me.
No problem.
Anonymous indicates that our bylaws only indicate good standing does not have a dollar amount. Do we assume it should be that they have to have a zero balance at the time of election? So I think I answered that during Mohammed's. If your good standing, and actually the statutory good standing language is, you do not owe anything. That, no charge, no assessment, no attorney's fee, no late fee, no nothing. If you don't have a zero balance, you can't vote. Now, as we said earlier, if the board wants to waive minor fees in order to get those people to be in good standing, it's free to do so. Next question, if we go to electronic voting, can an owner insist on paper ballot voting? Yes, as I said before, you have to have a consent from the owners who want to vote. That can be a permanent consent. We have forms for that. And it not only provides for consent to to electronic balloting, but it contains consent to electronic noticing if your bylaws have been amended to permit that to occur. Next question was really answered. Do electronic votes count towards a quorum? Good question. The answer is yes, that is in the Radburn law, because we anticipated that would be a possible issue, so yes, they do. If you are voting electronically, is there an option for a change of mind? Brett, do you want to speak to that?
Sure thing. So the software, and again, a question for all vendors that you might evaluate, but our software does allow where it's permitted for a voter to log in during an open voting period and change their mind. So in certain scenarios, you know, the last vote cast counts. In other scenarios, the first vote cast may count. So depending upon the specific requirements, the software complies and will permit a voter from logging in again, as long as the vote will close automatically based on the date that's been designated when the ballot was created. So if the vote is still open and a voter has a change of heart, they are, and it's permissible, they are able to log back in and make a change. And the last vote in that scenario will be the vote that's recorded for the tally.
Now, the only comment, a further comment I would make on that is that the Radburn law allows the board to make rules on issues that are not covered by the law. As long as the rules are not inconsistent, you can have an election rule. A board can consider an election rule that says, once you cast your electronic ballot, it can't be changed. Or once you cast any ballot, it can't be changed. So that's something you can consider as part of an appropriate election resolution. But if you don't feel strongly that that should be the case, as Brett said, you can have an electronic ballot that deals with that issue. Ellen Comiskey asks, can owners vote by phone as well as through an electronic voting system per the DCA? Arnold, do you want to take that?
Sure. No, a voter cannot vote by phone. If they select to vote electronically, they would submit their vote through that software. There would need to be a record of their vote in some mechanism. If it's in the electronic format, as Brett described, it would be recorded in that way. Otherwise, it would have to be submitted by fax, email, or by US Postal Service.
In fact, we should point out one additional thing that's not in the DCA regulations, but is in the amendment to the Nonprofit Corporations Act that actually allows annual meetings to be held virtually. And that is that people must have the opportunity to vote at the meeting. So the question arises, how do you do that? Well, the way you can do that is you can have a specified email address. It could be a new email address set up for that election, or it could be the manager's email address or the election direct overseer's email address, in which people can scan and mail their ballots during the meeting until the polls are closed. We've also created clickable PDFs. So if somebody says, I can't scan, there's no way I can send that. How do you do that ballot? Well, we can say to somebody, if you'll give us your email address, we'll send you a clickable PDF where you can click that and then send it back with an identification of who that person is, so we make sure that they are an owner and that they are in good standing. Rudy asks, do you have to be a resident owner to run for the board? The answer is no. That was in the Radburn Law. The only qualification is that you are an owner in good standing. Cannot be a requirement that you are a resident owner. So that's there. Michael Suchman asks, what are the effective dates of these regulations? Arnold? Arnold, you're muted.
Sorry, I don't have the effective date in front of me. I believe it was June of 2000.
It was actually May 18th.
I don't know why my mute keeps going on and off, but in any event, I got to get used to this. Sorry about that. May 18th was the effective date. I apologize.
And at this point, we've answered all the questions that were out there, either by email, by answering them in the question and answer box, or by dealing with them here. I hope you all enjoyed it. I am really thankful on behalf of all of the participants that we had such a great turnout and so many people came in. But if you have questions afterwards, there's the screen, there's the slide with the email addresses. Feel free to write to any of us if you have questions. As I said before, there will be a link to this email that will be sent to all participants. If you want to share that link with other people, or if you're a manager and you want to share it with board members, feel free. Anybody who wants to view this recorded webinar after the case will be there. And with that, I say on behalf of all of us, thank you again and have a wonderful afternoon.
Thank you very much, everybody.